If you've been scrolling through social media lately and seeing posts about green card holders losing their status in 2026, or if someone forwarded you a message claiming that permanent residents could be deported under new immigration laws, I need you to take a deep breath. I know how terrifying it feels when you see alarming headlines about your immigration status, especially when you've worked so hard to build your life in the United States. You're not alone in feeling this way, and that's exactly why I'm here today to walk you through what's actually happening, what's just noise, and what you truly need to know to protect yourself and your family. My name is Saqib, and this is Global Immigration Updates, your source for clear, fact-based immigration information, without the panic, without the politics, and without the rumors. I created this channel because I saw too many people making life-changing decisions based on incomplete or misleading information they found online. Today we're going to talk about green card immigration law in 2026, and I'm going to explain in the simplest possible terms what could actually affect your status, what's being misunderstood, and most importantly, what you should do right now. Let me start by addressing the elephant in the room. Yes, there are ongoing discussions in Congress about various immigration reform proposals. Yes, enforcement priorities have shifted under different administrations over the years. And yes, immigration law is complex and can feel unpredictable. But here's what you need to understand first. Your green card, which is officially called lawful permanent residence, is exactly what it sounds like. It's permanent. That means you have the legal right to live and work in the United States indefinitely. This status does not automatically disappear because of a change in administration or because someone proposes a new law. Immigration law in the United States operates under a system of due process, which means that any changes to your rights must go through proper legal channels, and you are entitled to defend those rights. Now let's talk about what people are actually worried about when they mention green card immigration law in 2026. There are several different concerns floating around, and I want to separate each one clearly so you know exactly what applies to you and what doesn't. The first concern is about deportation or removal of green card holders. The second is about changes to the green card renewal process. The third involves new requirements or conditions being added to permanent residents. And the fourth is confusion about who can actually lose their green card and under what circumstances. Let's go through these one by one. Starting with deportation or removal, this is the fear that scares people the most. Can a green card holder be deported? The honest answer is yes, but only under very specific circumstances that have been part of immigration law for decades. These circumstances have not changed in 2026, and they are not new. A lawful permanent resident can be removed from the United States if they commit certain serious crimes, if they engage in fraud or misrepresentation on their immigration applications, if they abandon their permanent residence by staying outside the United States for extended periods without maintaining ties, or if they pose a threat to national security. These grounds for removal are clearly defined in the Immigration and Nationality Act, and they require a legal process. You cannot simply be deported because someone decides they don't like immigrants, or because a policy shifts. You have the right to appear before an immigration judge, to present your case, and to be represented by an attorney. What's being misunderstood right now is that increased immigration enforcement does not mean random deportation of green card holders who are following the law. If you are a permanent resident, you have not committed any crimes, you file your taxes, you maintain your residence in the United States, and you renew your green card on time, you are not at risk simply because it's 2026 or because enforcement priorities have changed. Enforcement typically focuses on individuals who have violated the terms of their status or who have criminal records. This is not new, and it's important to understand that immigration enforcement has always existed under every administration. What changes is the level of resources dedicated to it and the priorities about who gets targeted first. The second area of confusion involves the green card renewal process. Your green card is valid for 10 years, and you must renew it before it expires by filing Form I-90 with USCIS. Some people are worried that the renewal process has become more difficult, or that USCIS is now denying renewals that would have been approved in the past. Here's what you need to know. The renewal process itself has not fundamentally changed. You still fill out the same form, you still pay the filing fee, and you still provide updated biometric information. What has changed in recent years is processing times. USCIS has faced significant backlogs, which means it can take many months to receive your new green card even after you've submitted everything correctly. This delay is frustrating, but it does not affect your status. As long as you file your renewal application before your current green card expires, you remain a lawful permanent resident even while waiting for the new card. USCIS will send you a receipt notice that extends your green card for a certain period, and this receipt notice serves as proof of your continued permanent resident status. There is also concern about USCIS requesting more evidence during the renewal process or asking for additional documentation. This is called a request for evidence, or RFE, and while it can feel stressful, it's a normal part of the process. USCIS may ask you to provide proof that you've been living in the United States, such as tax returns, utility bills, or employment records, especially if you've traveled extensively. This does not mean your renewal will be denied. It simply means they need more information to verify that you meet the requirements. If you receive an RFE, respond to it carefully and completely, and if you're unsure how to respond, consult with an immigration attorney. Now let's address the third concern, which is about new requirements or conditions being added to permanent residents. There have been various proposals over the years to make certain benefits or aspects of permanent residence conditional or to create additional reporting requirements for green card holders. As of right now, no such changes have been enacted into law. Proposals are not the same as laws. For any change to actually affect your status, it must pass both the House of Representatives and the Senate, be signed by the President, and then be implemented through regulations by agencies like USCIS or the Department of Homeland Security. This process takes time, often years, and there are opportunities for legal challenges if the changes violate constitutional rights or existing immigration law. If you hear about a proposal to change green card rules, do not panic. A proposal is just an idea. It may never become law, and even if it does, there are usually grandfather clauses or exemptions for people who already have permanent residence. The key is to stay informed through official sources like USCIS.gov or Congress.gov, rather than relying on social media posts or forwarded messages that may be incomplete or misleading. The fourth issue causing confusion is about who can actually lose their green card and how that happens. I've seen posts claiming that green card holders can lose their status for things like using public benefits, for not speaking English, or for not earning a certain income. Let me be very clear. None of these things will cause you to lose your green card if you already have it. The public charge rule, which evaluates whether someone is likely to depend on government assistance, applies to people applying for a green card or applying to enter the United States, not to people who already have permanent residence. Once you are a lawful permanent resident, using public benefits like Medicaid or food assistance does not make you deportable. There is no English language requirement to maintain your green card. There is no income requirement to keep your permanent residence. These are myths that spread because people confuse the requirements for getting a green card with the requirements for keeping one. What can actually put your green card at risk? Let me give you the real list so you know what to avoid. First, committing certain crimes. Not all crimes will result in deportation, but crimes involving moral turpitude, aggravated felonies, drug offenses, domestic violence, firearms violations, and fraud can all be grounds for removal. If you are arrested or charged with any crime, you must consult with an immigration attorney immediately, because even a minor conviction can have serious immigration consequences. Second, abandoning your permanent residence. If you leave the United States and stay away for more than 1 year without obtaining a re-entry permit, or if you take actions that show you do not intend to live permanently in the United States, such as giving up your home, closing your bank accounts, or taking a permanent job in another country, you can be found to have abandoned your status. Third, committing fraud or willfully misrepresenting facts on your immigration applications. If USCIS discovers that you lied on your green card application, on your visa application, or during your immigration interviews, they can revoke your permanent residence even years later. Fourth, engaging in activities that threaten national security, such as terrorism or espionage. And fifth, failing to notify USCIS of your address changes. As a green card holder, you are required by law to report any change of address within 10 days using Form AR-11. While failing to do this alone probably won't get you deported, It can cause serious problems if USCIS tries to contact you and cannot reach you. If none of these situations apply to you, then you are not at risk of losing your green card in 2026 or any other year. The vast majority of green card holders who live normal, law-abiding lives, who file their taxes, who renew their cards on time, and who stay in the United States or travel only temporarily have absolutely nothing to worry about. Now, I want to talk about what you should actually do right now to protect your status and stay informed. First, make sure your green card is up to date. Check the expiration date on your card right now. If it expires within the next 6 months, file Form I-90 immediately to renew it. Do not wait until the last minute. Processing times are long, and you do not want to be stuck without a valid card. Second, keep copies of all your immigration documents in a safe place. This includes your green card, your passport, your approval notices, your travel history, and any correspondence from USCIS. If you ever need to prove your status or respond to a request from immigration authorities, having organized records will make everything much easier. Third, if you plan to travel outside the United States for more than 6 months, apply for a re-entry permit before you leave. This permit allows you to stay abroad for up to 2 years without being considered to have abandoned your permanent residence. You must apply for it while you are physically in the United States, so plan ahead. Fourth, file your taxes every single year. This is not optional. As a permanent resident, you are required to report your worldwide income to the IRS, and your tax returns serve as proof that you are maintaining your residence in the United States. If you have been living abroad, or if you haven't filed taxes in several years, consult with a tax professional and an immigration attorney to understand how to fix this before it becomes a bigger problem. Fifth, avoid any criminal activity, no matter how minor it seems. Even a shoplifting charge or a DUI can have immigration consequences. If you are arrested, do not speak to law enforcement about your immigration status without an attorney present, and contact an immigration lawyer immediately. Sixth, stay informed through official sources. Follow USCIS on their official website, sign up for email updates, and check announcements from the Department of Homeland Security. Do not rely on TikTok, WhatsApp groups, or Facebook posts for immigration information. These platforms are filled with rumors, outdated information, and outright misinformation that can cause unnecessary panic or lead you to make bad decisions. And finally, if you have specific concerns about your situation, consult with a licensed immigration attorney. Not a notario, not a visa consultant, but an actual attorney who is a member of the bar and specializes in immigration law. Many attorneys offer free or low-cost consultations, and organizations like the American Immigration Lawyers Association can help you find reputable legal help. Let me also address one more thing that I've seen spreading online, which is the idea that immigration laws are changing so fast that green card holders need to apply for citizenship immediately to be safe. While becoming a U.S. citizen does provide additional protections and benefits, and I generally encourage eligible permanent residents to naturalize, you should not rush into it out of fear. Citizenship is a serious decision that requires meeting specific requirements, including continuous residence, physical presence, good moral character, and passing English and civics tests. If you are not yet eligible, or if you're not ready, do not feel pressured. Your green card remains valid, and as long as you maintain your status properly, you have time to prepare for naturalization when you are ready. One of the most important things I want you to take away from this video is that immigration rules, even when they do change, do not usually change overnight. There is a legal process. There are notice periods. There are opportunities to challenge unconstitutional or harmful policies in court. The U.S. immigration system, for all its flaws, does operate under the rule of law, and you have rights. If something genuinely changes that affects green card holders, you will hear about it from USCIS directly, from immigration advocacy organizations, from attorneys, and from reliable news sources. You will not find out about it first on Instagram or through a forwarded message. I know these are stressful times. I know it feels overwhelming to navigate an immigration system that often seems designed to confuse and intimidate. But I want you to remember that millions of people hold green cards in the United States, and the vast majority of them live their lives without any issues. They work, they raise families, they buy homes, they build businesses, and they eventually become citizens. You can do the same. Stay informed, follow the rules, keep your documents in order, and do not let fear control your decisions. If this video helped you understand the situation more clearly, I would really appreciate it if you would subscribe to Global Immigration Updates and turn on the notification bell so you never miss an important update. Immigration law can be confusing, but you don't have to figure it out alone. Share this video with anyone you know who might be worried about their green card status. Let's replace the rumors with facts and help each other stay informed. And if you have questions about your specific immigration situation, or if there's a topic you'd like me to cover in a future video, please leave a comment below. I read every single comment, and your questions help me create content that actually addresses what you need to know. Thank you for watching, and remember, stay calm, stay informed, and stay legal. If you or someone you love has filed an I-130 family petition, or is planning to file one, you may have heard something about a priority change coming in February 2026, and you might be feeling confused, anxious, or even panicked about what this means for your case. Let me be very clear with you right from the start. There is a lot of noise online, a lot of half-truths being shared on social media, and some people are spreading fear without giving you the full picture. That stops right here, right now. My name is Saqib, and you are watching Global Immigration Updates, where we bring you fact-based immigration news without the rumors, without the panic, and without the politics. Our goal is simple. We want to help you understand what is actually happening so you can make informed decisions about your immigration journey. Today, we are going to talk about the I-130 priority change that is being discussed for February 2026. We are going to break down what it is, who it affects, what it does not affect, and most importantly, what you should do about it. Before we dive into the details, let me say this. Immigration policies and processing procedures do not change overnight. There are systems in place, there are regulations, and there is a process for any major change. So if you have been losing sleep over a headline you saw on Facebook or a video that scared you on TikTok, take a breath. We are going to walk through this step by step, and by the end of this video, you will have clarity. So what exactly is this I-130 priority change that people are talking about? Let me start by explaining what the I-130 petition is, because not everyone watching may be familiar with the term. The I-130, officially called the Petition for Alien Relative, is the form that United States citizens and lawful permanent residents, also known as green card holders, file with USCIS to sponsor certain family members for immigration to the United States. This is the first step in the family-based immigration process. When you file an I-130, you are essentially establishing the relationship between yourself and your family member, and starting the process that could eventually lead to them receiving a green card. Now, once USCIS approves your I-130 petition, what happens next depends on a few things. It depends on your relationship to the person you are sponsoring, it depends on whether you are a U.S. citizen or a green card holder, and it depends on the country your family member is from. Some family relationships are considered immediate relatives, such as spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens. For these immediate relatives, there is no waiting list. Once the I-130 is approved, they can move forward with their green card application relatively quickly. But for other family relationships, there are annual limits on how many visas can be issued, and this creates what is known as the visa bulletin and priority dates. If you are sponsoring a sibling, an adult married child, or if you are a green card holder sponsoring a spouse or child, your family member will need to wait until their priority date becomes current before they can proceed with their green card application. The priority date is usually the date that USCIS receives your I-130 petition. So what is changing in February 2026? Here is what we know based on information that has been circulating and discussions happening within immigration circles. There are reports that USCIS may adjust the way it prioritizes or processes certain I-130 petitions starting in February 2026. Now, let me be extremely clear. As of the time I am recording this video, USCIS has not issued an official policy memo or public announcement detailing exactly what this priority change will look like. This is important. What we are seeing right now are mostly leaks, discussions, and preparatory notices, but not a final rule. From what is being discussed, the change may involve adjustments to processing times, changes in how cases are queued for review, or potentially shifting resources to prioritize certain categories of family petitions over others. Some sources suggest that USCIS may focus more heavily on clearing backlogs for immediate relative petitions or may reorganize how family preference categories are handled. There is also talk about whether USCIS might implement changes to how it assigns priority dates or manages the inventory of pending cases. Here is the key point. These kinds of administrative changes happen periodically. USCIS is constantly looking for ways to improve efficiency, reduce backlogs, and streamline processing. That does not necessarily mean that your petition is in danger, that your case will be delayed, or that the rules are being rewritten to your disadvantage. What it usually means is that USCIS is reorganizing internally to handle the volume of cases it receives. Now let me address some of the rumors and misunderstandings that are spreading online, because this is where a lot of the fear is coming from. Rumor number 1. The I-130 process is being canceled or shut down. This is completely false. The I-130 petition is a foundational part of the U.S. immigration system. It is established by law, specifically the Immigration and Nationality Act. USCIS cannot simply cancel it. Any major change to family-based immigration would require an act of Congress, not just an administrative decision by USCIS. Rumor number 2. All pending I-130 petitions will be rejected or need to be refiled. Also false. If you have already filed an I-130 and it is pending, it remains pending. Administrative changes to processing priorities do not invalidate petitions that are already in the system. Your petition will continue to be processed. What might change is the order in which cases are reviewed or how quickly certain categories move, but your petition does not disappear. Rumor number 3. Only people who file after February 2026 will benefit from the new system. This is misleading. If USCIS implements changes that improve processing efficiency, those changes could benefit both new and pending cases. Conversely, if the change involves reallocating resources, it might affect different categories in different ways. The point is, we do not yet have enough official information to say definitively who will benefit and who might see longer wait times. That is why it is so important to wait for the official announcement rather than assuming the worst. Rumor number 4. This change is political and targeted at certain countries or groups. There is no evidence to support this. Administrative changes at USCIS are typically about efficiency, resource allocation, and managing workload. They are not about targeting specific nationalities or discriminating against particular groups. If any policy change were to have a discriminatory effect, it would be subject to legal challenge and public scrutiny. So who is actually affected by this potential priority change? The honest answer is that until USCIS releases the official details, we cannot say with certainty. However, based on the discussions and the context, it is likely that any changes will primarily affect how USCIS internally manages its caseload. This could mean that some categories of family petitions are processed faster, while others might experience slightly longer waits. It could also mean adjustments to how cases are assigned to officers, or how backlogs are addressed. If you have already filed an I-130, your case remains in the system. If your I-130 has already been approved, and you are waiting for your priority date to become current, that waiting period is governed by the Visa Bulletin, which is managed by the State Department, not USCIS. Changes at USCIS regarding I-130 processing would not directly change your priority date or your place in line for a visa number. If you are planning to file an I-130 soon, it is worth keeping an eye on any official updates from USCIS, but there is no reason to panic or rush to file unless you were already planning to do so. Filing a petition before you are ready, or before you have all your documents in order, can cause more problems than waiting a few weeks for clarity. Now let me talk about what you should actually do. First, stay informed by checking official sources. The best place to get accurate information is directly from USCIS. You can visit uscis.gov, sign up for email updates, and check their news and policy sections regularly. USCIS typically announces major changes through official policy memos, Federal Register notices, or press releases. Do not rely solely on social media, YouTube videos, or secondhand information. Second, if you have a pending I-130, monitor your case status online through the USCIS case status tool. If there are any updates or requests for evidence, you will be notified. If your address has changed, make sure to update it with USCIS using Form AR11 so you do not miss any important notices. Third, if you are working with an immigration attorney, reach out to them and ask if they have received any official guidance about the February 2026 changes. A qualified attorney will have access to AILA, the American Immigration Lawyers Association, which often provides detailed analysis and updates on policy changes. Fourth, be patient and do not make drastic decisions based on incomplete information. Immigration is a long process, and it requires patience. Making hasty decisions, such as withdrawing a petition, filing duplicate petitions, or trying to switch to a different immigration pathway without proper legal advice, can cause serious problems down the line. Fifth, if you are planning to file an I-130 and you have all your documents ready, there is generally no harm in moving forward. Filing sooner rather than later can establish your priority date, which is important for preference categories. However, if you are not ready, do not rush. Take the time to gather accurate and complete documentation. Let me also remind you that immigration processing is governed by law and regulation. Changes to processing procedures, even if they affect wait times or case handling, do not happen in a vacuum. USCIS operates under the framework of the Immigration and Nationality Act, and any significant policy shift must go through a formal process, often including public comment periods and legal review. This means that even if a change is coming, there will be transparency, there will be guidance, and there will be time to understand and adapt. I also want to reassure you that the immigration system, while complex and often frustrating, is designed to process cases fairly and according to established rules. Delays, backlogs, and procedural changes are frustrating, but they are not the same as denial or rejection. Your case is still your case. Your relationship is still your relationship, and the law still provides a path for family reunification. One more thing I want to emphasize. If you are feeling overwhelmed or uncertain about your specific situation, it is okay to seek help. A qualified immigration attorney can review your case, explain how any policy changes might affect you, and help you make informed decisions. There are also nonprofit organizations and legal aid clinics that offer free or low-cost immigration assistance. Do not suffer in silence, and do not make important decisions based on fear. Before I wrap up, I want to remind you that immigration news can be confusing, and it can be scary, especially when you have loved ones waiting, or when your future depends on the outcome of a petition. But panicking does not help. Misinformation does not help. What helps is staying informed, relying on trusted sources, and taking thoughtful, measured steps. That is exactly why we created Global Immigration Updates. We are here to cut through the noise, to bring you the facts, and to help you navigate the immigration system with confidence and clarity. If you found this video helpful, please subscribe to this channel and turn on notifications so you do not miss any future updates. Immigration policies change, processing times fluctuate, and new announcements come out regularly. We will be here to break it all down for you in simple, clear language. If you know someone who is worried about the I-130 priority change or who has a family petition pending, please share this video with them. Knowledge reduces fear, and accurate information empowers people to make the right decisions. And finally, I want to hear from you. If you have questions about the I-130 process, about family-based immigration, or about any immigration topic, leave a comment below. I read the comments, and I do my best to respond or to create videos that address the questions you have. Your input helps shape the content we create, and it helps build a community of people who support each other through the immigration journey. Thank you for watching. Stay calm, stay informed, and remember, immigration is a process, not a race. We will get through this together.